Swayam Prabha. Digital India. Educated India.
Namaskar friends, welcome to SwayamPrabha DTH channel. My name is Dr. Parikshit Sirohi. I am Senior Assistant Professor, Faculty of Law, University of Delhi, and as part of this course on cyber crimes, this is the 10th and final lecture wherein we are going to be discussing about protection of software copyrights. So friends, throughout this course we have learnt various aspects of crime on the internet, starting with introduction to cyberspace. Then we have discussed the digital currency, we have discussed various kinds of frauds, we have discussed pornography in the previous lecture. Now friends, we are going to be discussing about the computer software and what kinds of risks that are there, what kinds of criminal activities take place with respect to the computer software on the internet. Friends, these are the topics that we are going to be talking about, dealing with in this particular session, and we are going to be first of all talking about how the computer software is to be granted protection, what is the existing regime, what is the position in the different jurisdictions. We are talking about India, we are talking about US, the European Union, UK. In the real world and the virtual world, how is copyright protection granted to the software, and how has the internet changed the existing things? We are going to be talking about that. Copyright is actually a bundle of rights. It allows the owner of the copyright to perform certain activities with respect to the copyrighted work. So we will discuss about that in relation to the computer software and see whether this bundle of rights which is available to the owner of copyright, whether it is available to the same extent or to a lesser extent or to a greater extent to the copyright owners in the in the internet, or how has the internet managed to change the position with regards to the copyright over the software programs. We will discuss about caching. We may have heard of the cache of the computer. We keep clearing the cache memory from time to time. How is this cache created? What is caching in the context of the computer software? And what are the different types of caching which are there? Friends, who has the responsibility for the violations which are committed with regards to software on the internet? Because please understand, software takes a lot of effort in creating. Now with the advent of internet, software may be created online instead of offline. The developer would previously create the software at his premises in his office, but now it may be created online, it may be disseminated online. The pirated or the unauthorized or illegal copies may be downloaded. It may involve computer programs, it may even involve movies, it may involve songs, it may involve pictures. So, who are the violators, and who for violations, who is the person whom we have to catch? Then friends, we will talk about copyright in various in the international regime. The TRIPS, which is the Trade Related Intellectual Property Rights Agreement, which was signed in 1994 after conclusion of the Uruguay round. How does that deal with the aspect of computer software in particular? How is it protected in copyright law? And we will also discuss the WIPO copyright treaty in brief. So, these are the points that we would like to deliberate upon over the course of the next 1 hour or so, friends. Friends, computer software, typically speaking, is a set of instructions. I am giving you the most simple and crude language very, very basic, crude definition which is available for the computer software. What is software? So, computer software is a set of instructions. It is a set of instructions which enable the computer to perform any given task. Whatever is the given task, how that task is to be performed, that is a computer software. For example, I may write a very simple software of how to add 2 plus 2 on the computer. So, that is how to do that through the commands, through the codes, that is software. In school or in college, you may have studied various computer languages. You may have written programs on your own, programs to add 2 plus 2 or programs to achieve very basic results. So, maybe in the language of BASIC or COBOL or C++ or Pascal, these were the languages which were taught in school at my time. So, maybe now Linux or more complex languages are being taught in school. So, during my time, these were the languages which were taught. So, the computer software is the instructions. The instructions may be in code, the instructions may be in words, the instructions may be in any other form. Let us look at the definition of the Copyright Act. So, in India, friends, we are protecting the, as we will see later, the in the entire gamut of intellectual property, the computer software is actually protected in more than one way. Some aspects of the software may be protected in some jurisdiction under patent, some aspect may be protected under copyright, some under trade secret, and so on and so forth. We will discuss that later as we go along. Now, friends, it is to be remembered that in the Indian Copyright Act, the Copyright Act 1957, which is been passed by the Indian Parliament, and it is amended from time to time. Even post TRIPS, considerable amendments were made in the law. In the Copyright Act, the definition of the copyright extends to computer software. Computer software is protected under a literary work. Now, lot of aspects of the computer programs are actually protected under patent law in the US, but all aspects in India, all aspects of the computer programs are actually protected as literary work in the copyright law. So, this is for understanding purposes. We have to know that it is protected under the literary work. It is actually the definition of the computer program under the section 2 FFC of the Copyright Act. As you already know, friends, section 2 is the definition clause which you will find in every law, and section 2 FFC gives the definition of computer program as set of instructions. See, I previously told you, set of instructions expressed in words, codes, schemes, or in any other manner, including machine readable format, which is capable of causing the computer to perform a particular task. Google Maps, it is a software. Truecaller, it is a software, to achieve a particular result. So, set of instructions, friends, expressed in words, codes, schemes, or any other form, including machine readable also, capable of causing the computer to perform a particular task to achieve a particular result. So, these are the 6 ingredients of the definition, friends. This definition is based on the WIPO model draft, the WIPO model provision for legislating in areas of copyright. The WIPO model draft, WIPO draft model provision for legislation in copyright. On the basis of this, how they have given it in the WIPO draft model provision, we have modeled the definition in our law. Friends, the internet, the main business of internet is software. It is the largest and most efficient distribution mechanism, internet, which has been created till date. The largest, wide dissemination, cheapest cost of dissemination is very low. It is widely accessible. The reach of the internet is immense. The number of users run into billions. The internet penetration is increasing in all countries, including extremely poor countries. So, it is the largest, most effective, most efficient, quickest, cheapest distribution mechanism which has ever been evolved by mankind. the internet is the largest forum for discussion on software. It is the largest market for producer of software. The internet, largest forum for discussion, largest market, largest producer, and unfortunately also largest source of piracy. It plays host to largest number of piracy websites. The internet hosts these piracy websites. The internet provides access to programs whereby the pirated software can be downloaded. The pirated software, unlicensed software, it may create problems on your computer. That is a different thing. It may cause your computer to malfunction. It may cause your data to be lost. It may cause your files to get corrupted. All those are other problems which you will suffer from. But the person who is creating the software, the company who is developing the genuine software, he is going to suffer, she is going to suffer because of the pirated software. The same thing like in the case of books, friends. If you are downloading the pirated version of the book, or you are photocopying the book cover to cover, or you are buying a pirated copy of the book at a traffic light, you may think that you have saved a lot of money, but in the long run you are committing a mistake actually. So similarly, it is my entreaty to all of you that do not indulge in internet piracy yourself, do not purchase or do not circulate the pirated software yourself, and do not either be a customer or a supplier of pirated software. So this issue of computer software privacy is actually not a new one, but the advent of the internet, like in a lot of other problems that we have faced, just in the previous lecture we talked about pornography. The pornography existed even previously, but with the advent of the internet, cyber porn came, which has increased the problem manifold. Banking frauds were taking place even previously, but with the advent of the internet, we started having cyber fraud, which added a new dimension to the problem. A serious problem was created. Friends, similarly in the case of the computer software, the issue is not a new one, but a new dimension has been added. It has the scale has been increased, the volume has been increased with the advent of the software piracy. Friends, now what is the existing regime for protection of computer software? Now I told you that there are various components of computer software. Some of them may be protected under copyright regime, some of them may be protected under patent regime, some under trade secrets, and again the practices will vary according to country to country. In India, all the aspects of computer software are provided protection under the Copyright Act. You have seen the definition of computer program under section 2 FFC. Previously you have seen this definition, and whenever the definition is given of a literary work, the computer program is included in that definition, friends, in the Copyright Act. So the IPR regime has posed problems for new technology like computer programs, certainly. Why so? Because the IPR law assumes that something is either a writing, which will be protected under copyright law, or it is a machine, which is an invention, which is protected under patent law. So please understand, the patent law is for invention. You develop a machine, you develop a process, you develop a way of doing something, that is a patent, invention. And the copyright law is for authorship. You write a book, you direct a movie, you make a song, you write a computer program, that is all protected under copyright law. You see any computer program, you will see copyright Microsoft Corporation. You see copyright Norton, if it is an antivirus, copyright Kaspersky. So these are all computer programs. So the C symbol with a round circle around it ensures that the copyright is being asserted. So if the this lecture were to be given to you, if the makers of the SwayamPrabha channel were to assert their copyright, I don't know if they are doing it or not. If they are making it free to air, then there is no copyright, but otherwise if they are asserting copyright, then they will also say the copyright SwayamPrabha. Right? Copyright may vest in an individual or in an institution. It may be copyright my name. If I have created this, if I were giving this presentation in my individual capacity, I would have asserted my copyright. Or it may be in the name of individual. Copyright IIT Kanpur, copyright Delhi University. So friends, the IPR law, if it is a writing, if it is something which is dealing with authorship, if it is something which is dealing with authorship, it is a writing, then copyright law. If it is dealing with invention, then protected under patent law. So, unfortunately or fortunately, the computer programs have aspects of both. Authorship is also there, invention is also there. So, that is why under Indian law, they are protected under copyright law, and most aspects of computer programs in US are protected under patent law. Certain aspects are protected under other forms of IP also. So, in that aspect, you may argue that the US law is actually a little more evolved than ours. It is debatable because in India, maybe if we were to segment, IP itself is a new concept in India, and if we were to segment various aspects of computer programs, the intention may be right, but maybe it will create more legal problems in implementation, friends. So, different forms of IPR are suitable for obtaining protection for various components or parts of computer software. So, for example, copyright is suitable for obtaining protection against near exact or exact copying of the source code, the program code. Copyright is also useful to protect certain aspects of user interfaces. Friends, the trade secret software which is available under licensing agreements can be used to protect the such components, the trade secret software. Then friends, trade secret protection is also available for source code and other internally held documents like program design. Friends, finally, the industrial processes. Friends, finally, the industrial processes which have computer elements, certain industrial processes which have the computer elements, certain industrial processes having the computer elements, they are eligible for protection under the patent regime. So, you have seen copyright regime, trade secret regime and patent regime. So, three different kinds of IP can actually be used to protect the various components of the computer software, friends. So, friends, the position of protection is actually different in different jurisdictions. In the UK, the Copyright Act of 1956 makes no mention of computer programs, but the next amendment on this act, which came in 1988 in the form of the Copyright Design and Patent Act, it makes a mention of computer programs irrespective of how they are stored. This is, friends, because in 1956 maybe the computer and computer programs, they were not so prominent from the point of view of the software. The computers itself were few and far between. I remember reading that when computers were being used in labs in India in the 60s and 70s, they used to be the size of entire rooms, and they needed special cooling systems to keep them cool. And today you have computers which are the size of a rice grain. So, you have several computers fitted into your mobile phone, in your car, in your watch, and the various devices which you carry around you. So, friends, the computers have evolved over a period of time, and so have computer programs. The hardware is what you see, but the more important part is what is inside, the software. So, probably because of that, in 1956 it was not, because computers were not so widespread, it was not there in the law in 1956 in UK, but it has been included in the law in 1988. Computer generated work is not created by the human, and special rules are required to determine the authorship and duration of copyright. So, it is machine generated work, so to say. So, in the general rule for copyright, as you are aware, in the Berne Convention, in the TRIPS, is the life plus 60. So, life of the author, life of the creator plus 60 years starting from the 1st January of the calendar year after the author has passed away. So, for example, the author is born in 1980 and he passes away in 2050. Then the entire life of the author from 1980 to 2050. Then starting from 1st January 2051, 60 more years. So, that means the work will be free from copyright 60 years after the death of the author, and which will be in this case 2111. That is when the work will be free from copyright. So, how do you determine when there is a machine generated work? So, this is the special rules have to be evolved to determine the authorship and duration of copyright. Friends, you may have heard of this very celebrated case of Naruto versus Slater. So, the problem that arose in this case is exactly the same problem, but in a different context, which arose in the case of software which is created on the internet or software which is created by a machine, not by a human. So, if a human is creating or an organization is creating, it is very easy to assert. But if the human is working on the machine and the machine is created, then also very easy. But if the machine itself is creating something, so the challenges posed by artificial intelligence, songs created by, poems created by artificial intelligence, what happens in those cases, friends? The same problem which is being handled by the courts in the case of Naruto versus Slater. This is popularly called the monkey selfie case, friends. Friends, you see such lovely videos on the internet and in the Discovery Channel and National Geographic Channel, wherein the tiger, the leopard and the lion and various kinds of wildlife are shown up close and personal. Do you think a cameraman is standing behind the camera at all times and the photo is being taken? No, friends. Just as humans are scared of animals, the animals are also scared of humans. And friends, the animals are blessed with a much greater sense of smell as compared to us. So, if there is a human in close proximity, the animal will simply not come there. So, all the camera traps which have been laid will go waste. So, typically what is done in wildlife photography is that a camera trap is laid, a camera is laid. There could be various kinds of cameras which are getting activated by heat, by motion. And moment the animal comes in front of the camera immediately gets activated and clicks, takes a photo. So, that is a camera trap. Now, in that case, if a camera trap is laid and the animal is coming in front and the photo is being taken, there is no problem. The copyright will go to the organization which created the film or the photo, or the cameraman who created the film or the photo. But here something very interesting happened, friends. The cameraman was working on a contract with a popular magazine and wildlife magazine, and he had set up a camera trap, and there was a monkey, a chimpanzee. His name was Naruto, and he came, he saw the camera, he got curious, and the photo was obviously taken by the camera trap also, because it was sensed the motion. But this monkey, it pressed the button, and because the monkey was in front of the camera and the button was pressed, it became a selfie of the monkey. Now, when humans take selfies, you take your selfie, or your brother takes his selfie, or your a friend takes his selfie, it is not big news, because humans take selfies. But if an animal is taking a selfie, it is big news, and that is why this picture became the subject of large amount of money. Because if there is too much of interest in the picture, then obviously it will be it will be commercially very expensive. And now the dispute is who should get the money. Should it be the magazine which had commissioned the photographer to take the photo? Should it be the Society for the Welfare of Animals, who had got themselves enrolled as the next friend of this monkey? Next friend is somebody who is appointed by the court as the person who is going to pursue the case on behalf of somebody who is not able to pursue the case. So, the person may be a lunatic or insane person or whatever, and next friend is appointed. So, since the animal cannot fight the case in court, the Society for Animal Welfare was appointed as the next friend. and the matter was settled outside of court, but a very important law was laid down by this, that look, even though it is written in law that copyright can only vest in a natural person and animal is not a natural person, so that is why the society came in as the next friend. So the out of court agreement was reached, whereby the society, the cameraman, and the person who had placed the camera trap, and the magazine who had commissioned the camera person, they all shared the revenue that came out of this photograph. So why I told you this short story, in case you are not aware of this case of Naruto versus Slater, the issues are similar. The copyright in a work which is created by a machine, the copyright in a photo which is created by a machine, or in this case a non-human being. So the law is the same with regards to machine or animal. The law says that copyright only vests in work created by a natural person. So natural person can mean a company, an organization, or a human being. Natural person does not include the animal, does not include the machine. So some similar kind of solution is likely to be evolved with regards to works which are created on the internet, the computer programs on the internet. Friends, the European community in the 1980s undertook to develop the IP protection for computer programs, and asked its member countries to harmonize their laws, bring it in consonance with whatever model laws were being made by the European community. The European community subsequently went on and became the EU, or the European Union. The EC directive was issued in 1991. It still holds the field, and it says that the computer program is to be protected. Now see what I said. The computer program is to be protected under the member states' copyright laws as literary work, and granted minimum protection of 50 years. Berne Convention says 60 years against unauthorized use. So with the coming in place of the TRIPS, this period of 50 has also become 60. So 60 years protection has to be given to every computer program, even if it is created by a machine, friends. In US, the Copyright Act of 1960 does not specifically lay down the computer program as a work of authorship, but history suggests that Congress considered the program, the computer program, to be copyrightable, brought it within the definition of literary works, but it is not explicitly written in the Copyright Act, friends. So that is why by and large they are protecting their computer programs under patent regime, like I mentioned. Congress has laid down exceptions to normal prescriptions against copying. Famous case of Apple versus Franklin Computers, and says that Copyright Act is actually going to exist to computer programs and application programs. So this judgment has extended the copyright protection, even though it is specifically not mentioned. Copyright protection is been extended by this landmark judgment to computer programs and application programs, and that is why I told you that the certain forms are protected under trade secret. Certain forms in the US may be protected under the copyright also. So friends, the journey from the real to the virtual world, how does it work for the computer software? In the computer software which is there in the real world, there is a comprehensive proper IP regime which is there. Does this regime also go and cover the software which is created on the internet? The software on the internet, will it also be covered? The answer to this question is unfortunately not a direct one. The copyright protection gives the author exclusive bundle of rights. We will talk about bundle of rights in a few minutes time, and the copyright protection is granting the author the exclusive bundle of rights to engage in certain kind of activities and license others to engage in certain kind of activities. Whether such a license is available in the case of the software which is created on the internet also, whether the internet software is also going to be covered by such protection, that is the question. Friends, with respect to computer software, the Berne Convention as amended by TRIPS and our own copyright law allow you to do certain things. It allows you to do any act as related to the work being a literary, dramatic, musical or artistic work, it allows you to sell or give on rent, give on hire, offer for sale or hire any copy of a computer program, irrespective of whether such copy has been given on rent or hire previously. These are the rights which are available with respect to computer software in the real world. And we have seen that in India, courts have applied by and large the same rules to the computer software in the internet arena also. The problem, however, arises when these specific rights get violated on the internet. And here the case of Yahoo Incorporated versus Akash Arora, one aspect of that can be studied. Yahoo versus Akash Arora, it is a judgment of the Honorable Delhi High Court. Friends, 5 areas come into play when dealing with internet. 5 aspects of copyright come into play when we are dealing with the internet. The first is creation of intellectual property. Second is uploading of content. The third is the transmission of content. The fourth is access of content, and lastly the use of content. So these are the 5 aspects of copyright which are coming into play when we are creating the internet, the computer software, transmitting it on internet or creating it on the internet. Friends, the creation of IP means the act of developing the software. Previously, usually it was taking place offline in the factory, or in the factory means office of the developer, the company which is developing it. So Microsoft develops software at its office, Google does so at its office, where the office of Alphabet, the parent company, may be located. But now a large amount of development of the software is actually taking place online. People are working at different locations and developing online. Certain cases it may be done interactively. So now it is a good time to look at the copyright as a bundle of rights. So if you go back to your understanding of the copyright law, section 14 of our law gives certain rights to every owner of copyright. And the owner of copyright in the language of the Copyright Act is defined as the author under section 2 subclause D. Friends, the author has the right of reproduction, including storage in electronic form. He or she has the right to have the public performance, display rights, fixation or recording of his or her performance. He has a right to make translation or adaptation, I beg your pardon. He has the distribution rights. He has a right to issue copies of the work, such copies which are not being already in circulation. We will talk about this in the context of internet created software. Friends, and he also has the right to create derivative works. What are derivative works? The book may be converted into, on the basis of the book, a movie may be made. On the basis of the movie, a play may be made. On the basis of a book, a play may be made. These are the various derivative works can be made. Now, from one computer software, another computer software may also be developed. So this is actually the bundle of rights of the author. So the author who is the owner of the copyright. So friends, now when we talk about the distribution rights or the rights to issue copies of the work which are not already in circulation. So certain computer software may be issued only to certain persons, and that is what we mean by licensed software. So every software, when you buy it, it comes with a key, and when you enter the key, that license is given to you. It may be a single user license, it may be a multi-user license. So for example, I have purchased a Kaspersky antivirus and it allows me to run it on 4 devices. The same, I purchase a Hotstar subscription, it allows me to run it on 2 TVs. So this is an example of a multi-user license. Now, friends, if I am going to make copies of such computer program which is not already in circulation, I am violating the rights of the author, and it is not even covered within section 52 of the Copyright Act, which deals with fair use. In other jurisdictions it is called fair dealings, the similar provision, but fair use also it is not going to be covered, because fair use is when you are making a copy for your own use. but here you are making the copies for distribution to others. If I purchase a single user license and I am using it on more than that by on more than that number of devices, more than one number of devices, then I am actually violating the terms of the license, and that is going to be illegal, friends. Friends, now we talk about caching and types of caching. These are very interesting topics, so I hope, friends, you are understanding and appreciating these. The caching is also called mirroring. What happens is, when we go and visit a website, the certain aspects of the website will actually, or the entire website in some cases, or complete set of material in some cases, will actually get mirrored or copied somewhere else. Why is this done? So that you don't have to repeatedly go to the same website again and again to get that information, so that there is speed. So it's like saying that, yesterday you fell sick, so the doctor gave you a prescription. 1 month later you again had the same symptoms. You said, why waste time, why wait for an appointment with the doctor, why spend money in the doctor's fees, let me simply go ahead and repeat the same prescription. That is not a smart thing to do, because you may have some other problem, or if the problem is recurring, maybe the doctor should know, so that he or she can advise you in a better manner. Similarly here, the computers are doing so for various purposes. Number one, it could be to speed up the repeated access to the same data. Number two, to reduce the network congestion, and it could also be to give a better user experience, enhance the user experience. So that could be the third reason why caching could be done. Now, cached material is usually stored at a site which is geographically closer to the user, so that it can be accessed faster, or on a more powerful computer, or a computer which has a less congested data path. Caching per se may not be illegal, but if the cache is used to replicate the software program, that is where it becomes illegal, friends. So the thin line between legality and illegality I have just demonstrated. Usually the storage is temporary, ephemeral, transient. It could be few seconds, it could be few days, a few hours, a few weeks. But if it is more than that, and it is done with nefarious intent, and if it is replicated, it is going to become a problem. Intent, like I told you, the question of mens rea, which we have studied earlier, if it is done with such nefarious intent, or if it is replicated elsewhere, then caching will become a problem. By itself, it is not a problem. Friends, the Copyright Act prohibits the storage of data, except when it is for ephemeral or transient purposes. For example, a broadcaster is broadcasting a live event. So how will he or she do it? He or she cannot do it until it is for a few seconds or for a few minutes it is actually recorded on his or her system. But if the broadcaster purposely starts replicating it, then, or makes copies of it, then that is going to be illegal. Transient, ephemeral storage, no problem, but other than that, the Copyright Act discourages it. So that is why caching, if it is only incidental, if it is for few seconds, few hours, few days, it is fine, but it should not be replicated. Friends, there are various kinds of caching that we know of. One is local caching and one is proxy caching. The proxy caching is done at the level of the server, and the local caching may be done at the user's end itself, on the RAM or on the hard disk. The purpose of caching I told you, and why caching or when caching becomes illegal we have seen. Friends, now violations take place. We have been discussing for the last few minutes the various instances of software piracy on the internet, and who are the persons who could be creating this? Website authors themselves. They could be replicating the software programs, they could be replicating content, so they should be made accountable. The browsers, the search engines, they are again major problem areas. The intermediaries, like the internet service providers, the direct liability may lie on the user, for example, but then there is contributory liability of the ISP. There may be contributory liability of the browser. So that is also to be fixed. Sometimes there may be vicarious liability. You are familiar with the concept of vicarious liability, wherein the master is responsible for the actions of the servant. So if a junior level employee is doing so, the senior level employee or the superior or the boss may be held responsible for the violation. If an organization does not discourage this by its employees, then the senior people in the organization should be held responsible. In the US, in some cases, they have even held the directors of the company responsible for if the employees are committing the piracy. Friends, there is limitation of liability which is provided under the Digital Millennium Copyright Act in the US. The several pieces of legislations are pending in various countries. For example, there is an important law which is being sought to be made in this area by Belgium. There is something which is under consideration in US. Germany is looking at it. Our own country is looking at it. The certain aspects to curb the software piracy. The certain aspects have been taken place, have already been addressed in the DPD Act of 2023 August. Japan has a task force which is looking into this aspect. So various countries, the legislations are pending, and obviously the end user who is making use of the pirated software downloaded through the internet, he or she is also responsible. It is not that you only blame the author or the search engine or the ISP. The user is the one who is finally responsible. So obviously that is definitely going to be the key. Friends, at the close of this presentation, let us just have a look at what is the international regime with regards to the software piracy. The TRIPS agreement, the Trade Related Intellectual Property Rights Agreement, talks about Article 1, para number 10. It talks about computer programs as a type of work which is eligible for protection under copyright law. Based on this provision in TRIPS, in most countries, the copyright law protects the computer programs, the software as literary work under the copyright law. Our own country does so. I have given the example of US also, where the courts have extended it in the Apple computers case. UK also follows the same. The European Community Directive also we have discussed. The computer program, whether in source code or in object code, to be granted protection under literary work as per the Berne Convention as amended in 1971, which was the later on subsumed by the TRIPS. Friends, the WIPO copyright treaty talks of the additional protection which is to be given to copyright, and because the IT has undergone the advances since the previous copyright treaties were made, and it provides certain other protection for copyright. As of August 2023, the WIPO has 115 contracting parties. We are also a party to WIPO, so this applies to India as well, the WIPO Copyright Treaty 1996. The WIPO Copyright Treaty and WIPO Performances and Phonograms Treaty, WPPT, these are the two treaties which are called the WIPO Internet Treaties, friends. So this is the Internet software protection regime internationally. So friends, as we have just had a look from this entire presentation, the scheme of things, the internet is a great medium for transmission of software. The internet is also a great medium now for creation of software, but unfortunately the internet is becoming a happy hunting ground for people who are wanting to commit the piracy of computer generated software, and this is the cause for concern. So like many other aspects of the issues covering the internet, because the internet does not respect your geographical space, the geographical barriers, it is transnational in nature. It is important that countries of the world come together, evolve uniform standardized protocols to deal with this problem. So thank you very much for your patience during this lecture and throughout the entire course. I hope you have found this lecture series to be informative, and I look forward to meeting you again as part of another course on the SwayamPrabha channel. Thank you very much, and happy studying to all of you.